There we go.
Great. Thank you, Simon. Appreciate you and Elizaveta inviting us today to present to Startup Estonia. We're happy to be here. Amber and I are Carter, DeLuca and Farrell. We're an intellectual property law firm. We're based in the US, but we work with companies and startups all over the world. And today we'll offer to you some guidance, advice, and strategies that can help your startup succeed and how to protect your intellectual property, which is really important. So the topics we'll cover today is why does intellectual property matter, the importance of intellectual property protection, the key types of IP that's relevant to most startups, and then aligning IP strategy with your business goals. A little bit about the workshop that Sim just mentioned. We'll give you a little briefing about that, but I'm sure the workshop will dive more into how to align your IP strategy with your business goals. We'll talk about IP agreements that are more common with startups, common IP issues and challenges that you are likely to face and how to overcome them. We'll talk about US provisional patent applications, which is a good, inexpensive way for startups to get a priority date with the US Patent and Trademark Office and then use that priority date to file their application internationally. And then patent protection strategies for Europe and the US, the EPO patent procedure, and then we'll talk about key takeaways and best practices, and as well as answer your questions at the end. So why does IP matter, especially for startups? So there are several reasons why intellectual property is important for startups. First of all, there's you want to protect your innovations. Intellectual property helps your startup protect its unique products, services, technologies, thereby ensuring competitors cannot replicate or exploit your innovations. In terms of trademarks, there's what we call brand differentiation. Like, for example, your logo, your trademark, your brand, they create a distinct identity, helping your startup stand out in the marketplace, and it builds customer loyalty. Attracting investors, which is really important. IP assets like patents or proprietary technology, let's say you're creating a software program, it makes your startup more attractive to investors because they showcase your business as having valuable and defensible intellectual property. And then there's monetization opportunities. Intellectual property can be licensed, sold. It provides additional revenue streams that can fuel your startup's growth, expansion, and the development and investment into new products and services. It gives you market exclusivity. Patents and trade secrets give your startup exclusive rights to specific products or processes, thereby reducing competition and creating a barrier to entry for others. And research has shown that technology startups with intellectual property are significantly more successful and valuable than startups without IP. So it's really important that you look to protect your intellectual property and you safeguard it as well. Now we'll talk about the importance of aligning your IP strategy with business goals. So aligning your IP strategy with business goals is crucial to maximize the value of your intellectual property while supporting your overall business objectives. And we'll go into some key steps to ensure that your business strategy aligns with your IP strategy. So first of all, you have to understand your business objectives. Start by defining what is your startup's long-term goals. Is it going to be market leadership? Are you looking to expand in other markets? Are you looking to be profitable in 5 months, 2, 3 years? And what are your innovative technologies? And then understand how IP can support these goals, whether through product differentiation, market entry, or cost reduction. And then identify the key IP assets. Determine which IP assets might be patents, maybe trademarks, copyrights, trade secrets. It could be one or more of the above, and which one of those are critical to achieving your business goals. For example, if market differentiation is a goal, trademarks and patents might be a priority. If you're a software company creating, let's say, a SaaS platform, then copyrights and trade secrets will be where you'll be looking at, and potentially patents as well. And then prioritize your IP protection based on value. Align the protection of IP with your business priorities. For example, if innovation and growth in a specific sector are your key goals, ensure patents and other protective measures are in place for your most innovative, what we call core technologies or products in that sector. So you may not be able to compete in all sectors. You may want to be market leader in a particular sector. You should align your IP strategy to make sure you have protection in that sector. And then you should constantly monitor market trends and what your competitors are doing. Regularly review market trends, competitors, potential disruptions to adjust your IP strategy. This ensures your IP portfolio remains aligned with shifting business strategies, such as entering new markets or defending against competitors. So it's important, like what we do at our law firm is we also look to see where your competitors are innovating, and you may want to pivot. So if you're a startup going into a new technology area and you notice that your competition is also has filed patents already and they may already have issued patents, you may want to pivot and go into a different part of that sector, not totally leave that sector, but you want to pivot so you don't run into their IP and have issues down the road. And then you leverage your IP for business development. You can use your IP strategically, whether it's a partnership, collaboration, and licensing opportunities that align with your business goals. An effective IP strategy can attract investment, open up new revenue streams, and increase your competitive advantage in the market. Now, Amber will talk about strategies for protecting your intellectual property and different forms of intellectual property.
So first up, in no particular order, we have trade secrets. So trade secrets are confidential business information that provides a competitive advantage or some sort of economic value or know-how. So this can take the form of software, processes, marketing, and business strategies, but more often than not, we see it take the form of formulas, formulations, and recipes. So a good example is the Coca-Cola recipe. It's not generally known to the public, which is necessary for it to be a trade secret. And in order to maintain trade secret protection, it needs to remain protected as long as secrecy is maintained. So you need to take reasonable efforts and put in place reasonable strategies to maintain secrecy. If that secrecy is lost, it is no longer a trade secret. So in the US, in the case of direct infringement or misappropriation, you can bring federal suit and ultimately recover damages and attorney fees. The caveat, however, is that these trade secrets can be reverse engineered or independently discovered without actually infringing upon your trade secret. So some strategies for protecting trade secrets include use of non-disclosure agreements or NDAs to ensure that employees, contractors, business partners, and suppliers protect the confidentiality of the trade secrets. You can also limit access and implement segmentation internally so that these secrets are accessed only on a need-to-know basis rather than everybody having access at all times. Regularly engaging in employee training and awareness is very important to inform your employees on the importance of protecting trade secrets and best practices for handling this very sensitive information. You can also put in place secure digital infrastructure, which could take the form of encryption or firewalls and secure networks to ultimately protect the digital trade secrets. Or alternatively, you can utilize physical security measures like using safes and locks and ultimately just monitoring the premises with security systems. And again, just to reiterate, the use of internal policies and procedures that really define what constitutes a trade secret and outlines procedures for handling, storing, and sharing this confidential information. And then just to do some due diligence on your part to monitor and enforce compliance to ensure that if there is a breach or some lack of secrecy present, that you take swift action to correct that. Now moving on to trademarks. So trademarks can take many forms, and these logos on the screen are just a couple of very recognizable examples. So it could take the form of words, names, logos, colors, fragrances, or flavors. In the case of product packaging and design, you can get trade dress protection. So again, a good example would be the Coca-Cola bottle shape, very iconic shape. they have trade dress protection for that shape. And then when we talk about logos, on the screen, you have the Nike swoosh or the Nike check mark. You don't even need to have the word Nike there to recognize what that is, because it is such a recognizable mark. And so these are really good examples of very recognizable trademarks. And for something to be trademarked, for a mark to be trademarked, it needs to have distinctiveness to be registered and ultimately receive trademark protection. So there are a couple categories of distinctiveness when it comes to marks. So first and foremost, we have what we call fanciful marks. So these are marks that are ultimately just made up words. So for example, Lilium or Joby, you hear it and you don't automatically associate it with any type of product or service. We also have arbitrary marks. So for example, Apple computers, no real correlation between the two. We have suggestive marks, so Airbus, SpaceX. Airbus make you think about airplanes or whatever it might be. Descriptive marks, so for example, hydrogen-powered aircraft systems, very literal description of what the product or the service is. And lastly, we have generic marks. So it is important to note that fanciful, arbitrary, and suggestive marks, whether they're made up or real words, are inherently distinctive and are immediately projectable. On the contrary, descriptive marks need to acquire what we call secondary meaning in the consumer market. So that means that consumers going out into the market need to see this mark and automatically associate it with your good or service in order to receive protection in the end. Generic marks, however, are never protectable. And it's also really important to keep in mind that trademarks that were once registered and were once distinct can lose their distinctiveness over time, usually through customer misuse, and ultimately become generic. So a good example off the top of my head here in the US, we use the word Band-Aid for bandage, very common in our everyday prose. And Band-Aid in the US is actually just a company that sells bandages. However, we've become so accustomed to seeing this company that people will just say, hey, let me get a Band-Aid. I'm going to just put a Band-Aid on it. And so because of that, the company, risks losing their once registered trademark because it becomes such a generic term. And again, this is customer misuse. So it's really important to just actively inform customers on how they should be properly using your mark, and that your mark should only be used in conjunction with your particular product or your particular service. We always recommend doing a trademark search before deciding a particular trademark, because this helps you better assess what is already out there, what's already being used, and in what spaces it's being used, to understand the kinds of rejections that you might get down the line. So some strategies for the protection of trademarks. First and foremost, the protection of trademark is limited to the country where it is being registered. So in the US, Australia, and Canada, we operate on a first to use gets right basis. However, in Europe, China, and Japan, it's a first to file gets right basis, which is consistent with our patent system here in the US. So you have two options for international trademark registration. First and foremost, you could file directly in each country or jurisdiction. So for example, going straight to the USPTO or going straight to the European Patent Office, or you can file in multiple countries with a single international application, thanks to the Madrid Protocol Agreement. So this reduces your application process down to one application that can then be distributed to various member countries. Now moving on to copyrights, as George had mentioned, these can be really valuable to software and tech startups. So this is legal protection for original works that are fixed in a tangible medium. So this could cover things like literary works, so it could be scripts or screenwriting, musical works like scoring or lyrics, artistic works, audiovisual works, and software works. So this could be unique lines of code that are being utilized for a specific application or whatnot. Copyright is very unique because the protection actually arises automatically upon creation. So there is no registration required. However, by registering your copyright, you can enforce your rights in court and ultimately access statutory damages in the case of infringement. Without registration, you cannot bring suit. So that's why registration is very appealing to many copyright owners. A copyright also grants you the exclusive right to reproduce the work, create derivative works, distribute copies, and ultimately perform and display the work publicly. So some strategies for the protection of copyrights. So ultimately, to effectively protect your copyright, you should ensure that your work is clearly marked with a copyright notice and is securely stored in a fixed, tangible medium. So that could take the form of a CD, a notebook, whatever it might be, something tangible on which you're actually fixing that particular line of code or script or whatever it is. Timely registration is also always encouraged to strengthen enforcement rights and enable access to statutory damages in the case of infringements. Again, organizations should always implement due diligence and internal policies for copyright compliance to actively educate your staff on permissible use and ultimately monitor unauthorized use online and in the marketplace. And when appropriate, make sure that you're taking legal action and issuing takedown notices to enforce your rights and deter infringement. Now moving on to patents. So a patent is very unique because it provides an exclusive right for an invention, process, or product that is new, useful, and non-obvious. So what this exclusive right provides you with is the right to exclude others from making, using, importing, offering for sale, or selling the invention in the jurisdiction where you have patent rights. What it does not give you is the right to make, use, import, offer for sale, or sell the invention, as that would be a negative monopoly. So in exchange for this right or this exclusive right, what you give the patent office is a disclosure relating to your invention. So you're no longer keeping it as a trade secret. You're making that public knowledge. You're releasing the invention to the public after the patent expires, which is 20 years from the earliest filing date. And this is common amongst all major countries at this point due to patent harmonization. So in the US, these are some general patent requirements. So first and foremost, your patent needs to be new or novel. So it needs to not be in what we consider the prior art. So these are things that are already patented or published. So it cannot already be publicly known. Additionally, it needs to be non-obvious. So obviousness is your measurement between the difference between what is in the prior art and what is claimed in your invention. So the prior art cannot suggest your invention, and your invention cannot just be some obvious improvement on what is already out there. And lastly, your invention needs to provide some sort of benefit to society. So it has to have a real world application or an application in a particular field or industry. And while these are the terms used in the US, these standards apply in all major countries, just take different names. And we'll touch upon this later on, but generally, European patent requirements are very similar to the US patent requirements. But in Europe, surgical methods and methods of medical treatment are not patentable, but medical devices are patentable. So again, what can be patented? So in most major countries, ideas, concepts, discoveries, scientific theories, so on and so forth, are not patentable. What are patentable are new and useful processes, machines, manufacturers, or compositions of matter. There are a couple of statutory exclusions that we have set forth in the US. This would include laws of nature, natural phenomena, and abstract ideas. So it's very important to be careful how you claim software and software hardware inventions to avoid getting a rejection under this particular statutory section. So generally speaking, if you are not able to clearly explain the steps of your software or your AI algorithm and its ability to ultimately solve a real world problem or offer a real world solution, the chances of being granted a patent in the US is very low. So some strategies for the protection of software patents. So software is more likely than not going to be deemed an abstract idea and not be patentable if it falls into one of these three categories. So first off, we have mathematical concepts, methods of organizing human activity, or mental processes. These are things that the USPTO deems that you could just do with your mind, essentially. So in order, again, to have a patentable software, you really need to know how to break down the inventive algorithm into a series of steps that can be explained. And ultimately, you need to explain how you're solving a real world problem and offering a technical effect in a new and non-obvious manner. If you can do that, then it will likely be patent eligible. Now to discuss US provisional patent applications, which are very attractive to many inventors and many companies because of their multitude of benefits and positive attributes. So some of the very beneficial aspects of filing a U.S. provisional patent application is first and foremost the fact that this application is not examined at the USPTO and it is not published. You can ultimately decide to keep the invention a trade secret. The US and all countries are first inventor to file regimes. So these provisional applications ultimately just get you a stake in the ground at the patent office and establish a priority date while postponing your decision to pursue domestic or foreign patent applications. The provisional application also does not affect your patent term, so it won't take away time out of your patent's life. Provisional patent applications are also very low cost compared to non-provisional or final utility applications and international PCT applications. And it just gets you to the USPTO or the European Patent Office much quicker, since there are fewer formal requirements than non-provisional final patent applications. And this in particular is very attractive to many inventors and companies. Filing a provisional patent application, because you are getting a priority date and a filing date at the patent office, allows you to use patent pending on your product, which can be really, marketable and really help you while you're trying to market. Some caveats regarding U.S. provisional applications. So first and foremost, any information that's not included in the provisional application will not be afforded the benefit of the provisional filing date. So you have to be very careful about making sure that you include all of the details that you would like to capture in your final application in your provisional application to benefit from that date. Additionally, as I've mentioned, it's really important to prepare the provisional application in a manner that complies with the same formal requirements of a non-provisional application or final application to ensure that you're not missing any gaps and that the conversion, because you have 1 year within which you can convert from a provisional application to a final non-provisional application, is really seamless and you're not missing anything and all your information is there and you have full breadth in your application. You should also consider filing provisional applications, even though NDAs are in place with third parties, because again, these don't get published. You can choose to keep them trade secrets. And so these don't go public at any point until you choose to actually convert it within a year to a final application. So this is a recommended filing strategy for startups. So first off, we recommend filing a US provisional application to secure an early priority date. Then you can, within 12 months, file a PCT or an international application for global protection. And then lastly, you can pursue US Track 1 accelerated examination for fast results. So on average in the US, from the point of filing an application to the point of issuance can take anywhere between 18 to 24 months. So it's quite a lengthy process. However, if you pursue the Track 1 option in the US, while there is a fee associated with it, we often see issuances take place within 6 to 12 months. So there is that benefit. It's much more expedited. Some companies are not so attracted by the thought of it taking 2 years to have a patent issued. And so they prefer to pay that additional fee and hopefully have something issued within a year instead. So the US Track 1 Prioritized Examination Program offers applicants a fast-track route to obtain a final decision on their patent application, again, often within 12 months of filing, which is extremely beneficial. So this accelerated timeline is especially valuable for startups seeking to demonstrate their innovation's commercial potential to investors or strategic partners very early on in their life cycle, rather than waiting that full 2-year span. A granted US patent under Track 1 can significantly bolster your credibility, support licensing efforts, and provide an enforceable asset while corresponding PCT and European applications are still pending, which often takes significantly longer to mature. It also helps you demonstrate value to investors and potential acquirers very early on, as I had mentioned. And it ultimately supports licensing and enforcement while your PCT and international EPO applications continue to depend. So these are some methods by which you can coordinate your US and your international and EPO filings. So a strategic global patent filing approach often begins with a strong provisional application, as I mentioned, that captures the startup's core inventions in a flexible and cost-effective manner. This early filing date establishes a priority date at the patent office and allows you to further develop the invention over the course of 12 months. During this time, the applicant can pursue the Track 1 examination route, on a corresponding non-provisional application to obtain rapid feedback. The examination results and claim amendments from the US can then be used to refine the claims in a subsequently filed international application, which can improve alignment with patentability standards and potentially strengthen the international application. By coordinating claim scope and arguments across jurisdictions, you ensure harmonized prosecution against all these various jurisdictions, you streamline examination, and ultimately you enhance the prospects for consistent and enforceable global patent protection. So we'd like to briefly discuss the patent prosecution highway, the PPH, which is also a very, very beneficial thing in existence to know of. So the PPH is an international framework that actually enables expedited examination of a patent application in one participating office based on a favorable ruling on patentability from another participating office. So a good example, if an applicant receives a positive examination result on a patent claim from the USPTO, they can then request accelerated examination of a corresponding application at the EPO under the PPH program. So ultimately, this process allows applicants to leverage the work that they've previously done in one office and potentially reduce duplication of efforts, shorten examination times, and improved efficiency. So to participate in the PPH, the claims in the subsequent application have to sufficiently correspond to those that have been deemed to be allowable in the earlier application. And the applicant must meet specific procedural requirements set by the respective offices. So your claims in, for example, the European application need to substantially mimic or mirror the claims that have been deemed allowable in the US in order to participate in the PPH. So again, for example, an applicant can first file a patent application within the United States. During examination, the USPTO might issue a positive ruling indicating that at least one of the claims is allowable. The applicant can then file a corresponding patent application with the EPO, either directly or via the PCT route by entering the European regional phase. After receiving the USPTO's favorable decision in the first application, the applicant can submit a PPH request to the EPO, including copies of the USPTO's office action, the allowed claims, and a claim correspondence table showing how the claims in the European application relate or correlate similarly to those allowed in the US. If the UPO determines that the claims are sufficiently similar and all procedural requirements are met, it will accelerate the examination process. So again, this can lead to a faster issuance or resolution of the European application by leveraging the work that has already been done in the US. Now I'm going to pass it off to George to just briefly discuss some intellectual property agreements.
Thank you, Amber. So intellectual property agreements are an effective management tool for intellectual property, especially for technology startups, because it gives you the ability to rely on clear and enforceable agreements. So we'll talk about several of the agreements that are common when it comes to intellectual property. First is licensing agreements. So these agreements enable companies to monetize their IP assets by granting usage rights to third parties in exchange for royalties or fees. And also you can use a licensing agreement if you are looking to license, let's say, technology from a university or a research institution. In that case, you will be the third party licensing the technology from the licensor. So licensing agreements can be both beneficial to you to get a royalty from a third party, but also beneficial in being able to acquire technology that you don't want to spend the resources to develop, and somebody else has the IP for that technology. And then there's non-disclosure agreements, which are essential for protecting sensitive information during discussions, development, and negotiations. And then you have joint venture agreements, which facilitate collaborative innovation while ensuring that ownership and usage rights to jointly developed IP are clearly defined. So joint venture agreements, if you go into a strategic relationship with a third party and you're going to be developing technology together, it's important that the agreement specifies who will own the intellectual property that's going to be developed from that collaborative effort. It could be jointly owned, it could be owned by one party and not the other, and everything in all different types of combinations. But the agreement should be clearly define how that ownership will happen, so there's no issues later on. And then you have employment contracts, which should include assignment clauses to ensure that IP created by your employees within the scope of their duties is owned by your company, your startup. along with employees having a confidentiality obligation to safeguard proprietary information, for example, your trade secrets. So it's important that from the get-go, from the early beginnings of your startup, if you haven't done it yet, please look to have every employee sign an employment contract where they specify they will assign all their intellectual property to your company, and that they will have the obligation to keep everything confidential. Other agreements that you may come across are independent contractor and consultant agreements. So all contractor and consultant agreements should be read with care to ensure the company, institution, your startup owns the IP, if that's the intent that is generated under those agreements, and that the contractor consultant has an obligation, just like we said earlier with your employees, to assign the IP to your company and institution. So if you are speaking with a consultant, it's best to have a consultant agreement in place rather than just an informal conversation, because then there's nothing is written. They don't have an obligation to assign the IP to your company. So it's important to have these agreements with consultants, independent contractors on paper, and clearly define that they have the obligation to assign the IP to your company. And these agreements should be done, obviously, before you retain them, because sometimes if you go back to a consultant after they've done all the work and you tell them to sign, they may not agree to sign. So early on in your engagement with a consultant, an independent contractor, have them sign an agreement. And then there's third-party development agreements. This usually comes into place where you are developing the technology, but then you may need a third party to develop a piece of the technology that you internally may not have the resources to do, or you may go to a third-party software developer to develop a software program. So before entering into these agreements or any form of discussion or collaboration, you should document all your innovations and IP that you developed up to that point or that you envision your company will create, and then file provisional applications to get a filing date prior to any meaningful discussions. This is because when you go to the third party and you tell them develop this piece of the technology that will work with my system or with my program, and they develop the software, they develop a piece of the hardware, they have rights to that IP unless they previously signed an agreement that you will be the owner of that intellectual property. So it's important you get these agreements done before any work begins. And then again, similar to what I just said earlier, software development agreements, be sure to include who will own the software. When you talk with software developers, almost always, if they give you their agreement, it always says that they own the software and they are licensing it to your company, but that may not be what you want. You may want to own the software and not the software developer. So you make sure the software developer agreement specifies that your company owns the software and the source code, and that it's not being licensed from the software developer. So it's important to have that clearly defined from the beginning. And then when it comes to work for hire in terms of copyright, make sure agreements with third-party developers, contractors that are to be interpreted under the U.S. Copyright Act include work for hire provision. So any creations that are subject to copyright protection, such as the software, the source code, any manuals, belong to your company. So like Amber said earlier, when it comes to creating a source code or creating something that's copyrightable, the creator owns the copyright. Unless you have a work for hire provision in your agreement, they will be the owner. So it's important that software developer agreements, any agreements when it comes to creating a logo, your manual, are a work for hire arrangement, and therefore you will be the owner of the copyright in that work.
Now we'd like to briefly discuss patent protection specifically in Europe and how this might differ from what you've already heard us discuss about the US. So in Europe, unlike in the US, Methods of treatment of the human or animal body by surgery or therapy and diagnostic methods practiced on the body are explicitly excluded from patentability. So this can take the form of surgical techniques, therapeutic regimens. So for example, administer X milligrams of this drug Y once daily, or in vivo diagnostic steps. So another example could be blood test interpretations that are done directly on the human body. So because of this, health tech startups should claim devices, systems, or compositions rather than these methods and techniques and regimens. And again, just to reiterate, software patents need to solve a technical problem in a novel way in order to be deemed patentable. So you must avoid claiming diagnostic or therapeutic methods directly. Rather, focus on apparatus, medications, or computer implemented tools such as medical instruments, diagnostic tools, or imaging hardware, rather than the diagnostic or therapeutic methods that I previously alluded to. This is more of a practical recommendation, but you can include Swiss type claims when applicable. So for example, the use of compound X in the manufacture of a medication for treating condition Y. This would be deemed okay because you're setting forth what particular compound you're using in the manufacture of a particular medication to treat a particular condition. Additionally, you'd like to protect software or AI-based health solutions by emphasizing the technical contribution. So for example, an image processing algorithm for tumor detection on MRI scans. So you're setting forth very clearly why you're utilizing this image processing algorithm, which is to detect tumors on MRI scans. So again, unlike in the US, pure software or business method patents are not allowed in Europe. So software needs to provide a technical solution to a technical problem and have some technical character. So a couple of examples of patent eligible software in Europe, so these are softwares that can be patented, include control systems for machines or devices, enhanced user interfaces that reduce hardware resource load, or algorithms that can improve technical processes like encryption or signal processing or medical imaging, like I previously alluded to. Now to discuss an EPO-specific patent procedure and how you might enter the EPO as an individual seeking or a company seeking patent protection. So first and foremost, the European patent prosecution process begins with, at step 1, formal examination. So an examiner is looking at your patent and comparing it to what's the prior art is, what's already out there. And this is where the EPO verifies that the application meets all filing requirements, such as completeness, correct formatting, and timely fee payment. And we have a very similar step in the US. Once the application is formally accepted, the process then moves to step 2, which is when you're issued a European search report or an ESR, which includes a list of relevant prior art and a preliminary written opinion on the patentability of the invention. So this is a really attractive part of the EPO patenting system because this report helps the applicant assess the strength of their claims early on. So you kind of get an idea of how patentable your particular invention is before you go to formal examination. And you also are provided with this list of prior art that can be cited against you later on down the line. And it helps you determine if you'd like to continue moving forward or if you maybe want to stop the process there. So this is a really nice step of the EPO process. So to proceed, the applicant must file a request for substantive examination at step 3 within 6 months of the publication of that search report that I just discussed. So during this stage, the examiner will review the application in detail, considering its novelty, its inventive step, which can be equated to the obviousness requirement in the US, its clarity, and other substantive requirements as well. Based on the outcome, the EPO will then either issue a grant decision saying your patent is allowed or a refusal at step 4. So if granted, the applicant can proceed to validate the patent in selected countries or request the unitary patent, which I'll discuss in further slides, to simplify coverage across multiple EU states. It is very important to note, because we previously discussed filing PCT applications, if none of the applicants or inventors are residents or nationals of the United States, and for example, they are all based in Estonia or other European countries, they cannot file a PCT application through the USPTO. Instead, what you need to do in that case is you need to file your PCT application or your international application through the EPO or their respective national patent office. In doing so, you are required to be represented by a qualified European patent attorney, as you would a U.S. patent attorney in the U.S., as only authorized representatives are permitted to act before the EPO on behalf of applicants. Engaging a European law firm or European patent attorney ensures compliance with procedural requirements and enables you to navigate both the PCT filing process and subsequent prosecution stages very efficiently. So these are just a couple of cost considerations that we'd like you to keep in mind. So the EPO's fees do include a filing fee, a search fee, an examination fee, and a designation fee, which covers all EPC contracting states. So these are all the countries that you could potentially enter into within the EPO after you file your initial application. There are some additional costs to consider as well. So that could be translation expenses, especially when you're filing at a national validation stage within a particular country. Translation might be necessary. Again, professional representative or patent attorney fee should be considered. And now the unitary patent system is a very beneficial system and offers lower post-grant costs by eliminating separate national validations. It offers a single renewal fee for all participating EU states and a very streamlined enforcement and management of your patent, of your application. So what is the unitary patent? The unitary patent is a single European patent right, providing uniform protection across multiple EU member states. This right is granted by the EPO based on the standard European patent application, and it ultimately eliminates your need to file separate national validations in each and every European country that you'd like to enter into. Another very attractive feature of the unitary patent is the fact that it involves one translation, one renewal fee, and central management across all EPO member states. It also enables simplified enforcement through the Unified Patent Court. It is important to note that this is only available in participating EU countries. There are about 18 countries that participate in this that you can see on the screen. So that includes Austria, Belgium, Bulgaria, Denmark, Estonia, Finland, France, Germany, Italy, Latvia, Lithuania, Luxembourg, Malta, the Netherlands, Portugal, Romania, Slovenia, and Sweden. So those are countries where you can participate in the unitary patent and you can benefit from the very attractive features of the unitary patent system. Again, that one translation, one renewal fee, and central management, and ultimately just one single application rather than a multitude of fees that need to be repaid.
Okay, now I'll talk about key takeaways and best practices, and then we'll follow up with questions. So here are key takeaways for the European startups. So you should conduct regular IP audits to identify, classify, and evaluate the status and value of all your intellectual property assets across your organization. Definitely educate your staff on the importance of IP protection, including internal training programs on invention disclosure, confidentiality, and compliance. Having training sessions on a regular basis to make sure people understand what is a trade secret, what in your company are trade secrets, about invention disclosures. Invention disclosure is basically a document that your researchers, engineers should be filling out, disclosing what they are working on, what problems they're solving, and then you can then review that to determine if there's anything there that could be potentially patentable that you may want to protect, or there may be a trade secret that needs to then be identified. And then integrate your IP strategy into your overall business planning, align it with product development, market expansion, and competitive positioning of your goals. And then approach IP issues strategically with professional European and US counsel. It's never too early to get a US Patent Counsel or European Patent Counsel on your team so they can advise you accordingly. For example, when to file a provisional application, to do a trademark search, maybe to look at an agreement that you're looking to sign with a software developer, making sure that you don't trip up and cause issues down the road. And then be mindful of subject matter restrictions, especially in health tech. Like we said, you cannot protect surgical methods in the European Patent Office, so you may want to draft your claims differently in those type of technologies than you may have claimed them in the US. And then leverage US speed and PCT breadth to build a robust IP portfolio. Definitely do track one. I think track one is a good way to get an early allowance in the US and then use that to your benefit to enter the patent prosecution highway in other countries, and therefore get your PCT portfolio and your IP portfolio growing quicker than you have done in the normal course. And then here, key takeaways for filing at the EPO. Do not claim methods of treatment or diagnosis directly. Focus your claims if you are health tech on medical devices, systems, or compositions of matter. Use Swiss type or EPC compliant use claims for therapeutics. And consider AI-based diagnostics tools as technical inventions if they improve clinical outcomes. And then pair your European Patent Office filings with the Track 1 prosecution in the US to get quicker prosecution and allowance in the European Patent Office. Then avoid pure algorithm and business method claims. Frame your inventions around solving a technical problem, especially if you're using AI or machine learning to develop some invention. You should explain how your algorithmic software solves a real technical solution. And then highlight system level impacts, improve performance, lower power use. It's important to identify what are some of the characteristics of your invention that will make it non-obvious. And then protect user interface and user experience innovations if they provide measurable technical benefits. So if you're doing something in the software space and you have a particular user interface, it could be protectable, something to look into. It could be a copyright, it could be trade dress, it could be trademark protection. So it's always important to look at all aspects of what you're developing and coordinate your PCT strategy with your US filings for broader flexibility. And I will take questions, and you can also connect with us on LinkedIn. Those are our QR codes. If you have specific questions or you want some specific guidance on your particular startup, or maybe you have an issue that you came across, we'll be happy to also talk to you if you reach out to us and try to help you along. But yeah, now if you have any questions, we'll be happy to answer them.
Thank you, Georgia, and thank you, Amber. We will now wait for questions for a bit. And maybe I will start. I have some for you. I wanted to ask how to choose a country for protection, for patent protection. I mean, when Estonian company should go to the US? What are the benefits for the Estonian company?
Sure. So in the US, we have the provisional application. So if it's a very good tool, and that's only been around for like 20 years. It's not been around for a long time, but startups can benefit from filing a provisional application, because once you come up with an idea or a new technology and you do a patent search and you see that it could be potentially patentable, filing a provisional application is the best way to proceed, because now you have an early filing date, but you still need to develop the technology. You may still want to figure out how it will operate, and you don't have all the answers. And as you are working on your technology, you can file another provisional application as those things become more clear. So you're not limited to one provisional. So during that 1 year before you convert it to a regular US application or international application, you can file 2 or 3 provisional applications, putting stakes in the ground as you develop your technology. And therefore, or if you are going to be talking to third parties, maybe investors, it's always best to file a provisional application, even if you have an NDA in place, because they may come back to you with their ideas. And then later on, they may think that you took their ideas and got a patent issued. But if you can show that your provisional application with all these ideas was already in the patent office, it's a timestamp that you had these ideas before you had any discussions with third parties. So provisional application is always what we recommend if you're a startup and just starting out, or if you're in business for a few years and you still are working on your technology, but you don't yet you're not ready to file a regular application, because a regular application will be examined, and once it's filed, you cannot add to it anymore. Whereas a provisional, it's not examined. You can follow up with another provisional, and then when you are ready file your regular application within that 12 months.
Yes, thank you very much. I think, yes, it's quite good to know about the provisional application procedure. We don't have this thing in Europe, but maybe you can give us more details on the US market. I mean, when the Estonian companies should be interested in the US market at all to protect their patent in the US.
Sure. So so after you file a U.S. provisional, then you can follow up with a European Patent Office application, and you don't have to file in the U.S. And maybe after you file your PCT, you can file your U.S. application of the PCT. So companies should be looking to protect in their geographic region. So if you're an Estonia startup, obviously you want to protect in the European Patent Office first. But since the European Patent Office, like you said, doesn't have a provisional, you can file a provisional in the US and it's recognized in Europe. So when you file your European Patent Office application, you claim priority to your US provisional and gives you that early 1 year, up to 1 year early filing date. And then from your European Patent Office application, then you can also file a PCT application at the same time. And from the PCT application, you can then enter the US with the regular US application. But each company is different, what their business goals are. So if you're looking to, obviously US is a big market. So definitely have that as your business goal to protect your intellectual property in the US. Now, since the EPO takes a long time to examine applications, we always recommend filing a track 1 application sooner than later in the US, because you may get a US patent before the European Patent Office even examines your application. And if you get a US patent, it looks good to investors. You can then enter the patent prosecution highway with your European application and then fast track your European application because you already have issued a US patent. So we think the best strategy is always to look to file in the US sooner than later, because you can do the track 1 if you're looking to get a patent sooner.
Thank you. I was received question in the chat. Can you see it? It's about the cost of the US patent application procedure.
Yeah, so the cost structure varies. Like when it comes to preparing a provisional application, it's usually less expensive, obviously, than the full application. But if you're doing a consumer product and you have very detailed mechanical drawings, it may cost maybe 2,000 to 3,000, because drawings can be described in a few pages, and that's your whole provisional application. But if you're working on a large system, maybe a robotic system, and there's more parts to describe, more things to elaborate on, it may be more like 7,000 to 8,000 for provisional, because there may be more information. The more you include, like Amber said, if you don't include something, it doesn't get the priority date. But we work with startups in the sense that if you are developing your technology and you have a white paper, you have some presentation, a provisional application can include all that. It doesn't have to be, it's not a formal patent application like your regular application. So some startups will have technical drawings. They will have some white paper. They may have a presentation, and we look at that presentation and take all the technical information. We don't need to know about your marketing strategy, or your projections, that's your trade secrets, but anything technical can be put into the provisional application and lower the cost because you may have a lot of that information already. So we don't have to write it from scratch.
So a couple of more questions from me that I've written down in the chat as well, just so I don't forget them. But you also mentioned the PPH track, so combining them with the track 1 at the USPTO. So once you get like the patent allowance notification from the USPTO, what's like a reasonable time frame to expect to get to a patent through the PPH, that, let's say, to a unitary patent? at the EPO?
So I think it depends on, for example, if your first application was filed in the US and your subsequent application was filed in the EP, it depends on the route that you pursued in the US, of course. So first and foremost, if you're doing the traditional examination route in the US, that can be a very, very lengthy process.
No, I mean, so once I get like this notification
Once
from
you
the
get
USPTO, yeah.
So I think generally within a couple of months, you can have your patent application verified in the EP, maybe even quicker. And so it's a very, very sped up process. So once you have that indication of allowability in the US, you submit that to the EPO. It should be a very rapid turnaround time. I would say probably at most a couple of months. Yeah.
Okay. So what would be some reasonable critiques of the provisional system? So when would it make sense not to file a provisional, or rather sort of go straight to the full patent?
Sure. So it depends on where you are in your technology phase. Like usually we find with software companies, they should be filing a provisional application first because software is usually in being developed. They may have more features that they may come up with that they don't want to change themselves and file a full application only to find out later that they came up with some feature or some user experience, a user interface that could have been added to the application. So with software, usually we want to wait and file provisionals and wait on the regular application. But when it comes to hardware, that if you're developing hardware and you're fairly along the way and you've done a lot of the work already and almost have developed the entire, let's say, robotic system, then a full application may be the best way to go, and then file it under track 1 to get early examination. But if you find it's a case-by-case basis, but the more further along you are in your technology development, it's better to file a full application than if you are earlier in the process.
So
and also, also with provisionals, like we said, like you can if there's a question of whether you want to keep it as a trade secret or not, it may be best to file a provisional so you don't have to make that decision for a good year. Whether, let's say, you're filing you're doing some work on a software program, and it could be something that could be kept confidential, but you're not sure yet whether you want to get a patent or try to get a patent or maintain the functionality of how these software works as a trade secret. If it's possible, you don't have to make that determination much until later if you file a provisional.
We have a question from Sigrid Selberg. Sigrid, would you like to present the question yourself?
Hello. Yeah, I have a question. It's in the case of therapeutics. For example, if the European Patent Office considers that the first patent covering the mechanism of action of this class of therapeutics, and also it covers broad area of different diseases, and for example, if you submit the next patent application targeting a single disease, and the result is that the European Patent Office said that, okay, for example, you can't patent this single disease because it was claimed in the first patent application. Then in case of the US Patent Office, can you still patent single diseases, or it's the same, that if your first patent covers a wide range of diseases and method of action, then it's covered, or it's how is it?
Yeah, that's not my expertise. My background is electrical engineering, but I can refer you to our life science Dr. Carmela Stevens, who does life sciences. But I think the answer is yes. But I'm not 100% sure. I would please reach out to us, and we'll direct you to Dr. Stevens, who handles. She's a biomedical background, because my understanding is if it's unique and non-obvious to something that may perhaps you come up with a new disease that could be treated with a particular drug, it could be patentable, but definitely reach out and we can get that answer for you, so we're certain that we give the right information.
Yeah, and just maybe to add to that, there is also sort of the question sort of if the rejection was based on novelty, in that sort of you already disclosed the both the agent and the mechanism and the disease that you want to sort of affect with the medication, sort of that would sort of be novelty destroying and hence would be grounds for rejecting the patent application. But sort of if in the meantime you made some sort of additional sort of developments into the technology, sort of to make it more specific, let's say, to that specific disease, then that sort of addendum or that sort of addition to the original technology, that in its own could substitute constitute a new patentable subject matter. Yeah.